that should terrify every powerful person who has ever reached for a lawyer the moment someone said something they did not like. It is a pattern that is playing out in real time across multiple cases involving multiple plaintiffs, and the verdict is becoming impossible to ignore. The pattern is this: powerful people, people with money and connections and access to expensive legal teams, are discovering that using defamation lawsuits as weapons of intimidation is not just failing, it is backfiring, catastrophically, publicly, and in ways that are leaving the people who filed those lawsuits in significantly worse positions than they were in before they ever walked into a courtroom. 2 days ago, Laura Loomer lost her defamation lawsuit against Bill Maher and HBO. She lost it completely. She lost it on summary judgment, which means the judge looked at her case and decided it was so legally insufficient that it did not even deserve to go to a jury. She was seeking $150 million in damages. She got nothing. And the reasoning the judge used to throw her case out, the specific legal logic at the heart of that ruling, is so directly applicable to Melania Trump's situation with Michael Wolff that Wolff's legal team almost certainly read that decision and felt something very close to relief. Because what Judge Moody said about Loomer's lawsuit is, almost word for word, the argument that Wolff has been making about Melania's legal strategy since the very first day this fight began. Stay with me. Because what connects these two cases is not just legal theory, it is a fundamental truth about what happens when powerful people mistake the courthouse for a weapon and discover too late that weapons have a way of turning around. Let us start with Laura Loomer, because her case is the freshest, and because understanding exactly how and why she lost is essential to understanding what is coming for Melania. Loomer is a far-right political activist and commentator with a direct line to Donald Trump. She has been a fixture in MAGA political circles for years. She ran for Congress twice. She has sat in the Oval Office. She has had conversations with the president that most people in American political life would envy. She is, by any reasonable measure, a prominent public figure with significant resources, significant access, and significant legal backing. In September 2024, Bill Maher made a joke on his HBO program, Real Time. He suggested in the comedic and deliberately provocative style that anyone who has watched his show for more than 5 minutes would immediately recognize that Loomer might be having a romantic relationship with Donald Trump. He said he thought maybe she was in an arranged relationship to affect the election because of her sudden closeness to Trump in the news. He added, and this is the line that Loomer's lawsuit centered on, that he thought it might be Laura Loomer when speculating about who Trump was seeing outside his marriage. It was a joke. It was delivered in the context of a comedy program. It was received by the audience as a joke, and Loomer sued him for $150 million anyway. Now think about the strategic logic behind that decision. Loomer believed, or her legal team believed, that the lawsuit would accomplish one of two things. Either Maher and HBO would settle quickly to avoid the cost and reputational mess of a public trial, in which case Loomer would extract money and a retraction, and the joke would effectively be erased from the public record. Or the case would proceed, and Loomer would use the discovery process and the public platform of a courtroom to make Maher's life sufficiently uncomfortable that he would think twice before ever making a similar joke again. It is a strategy that has a name. It is called a slap suit, a strategic lawsuit against public participation. The purpose is not to win in court. The purpose is to make the cost of speaking so high that people calculate it is not worth it. The purpose is silence through financial threat. And it is a strategy, it is worth noting, that Melania Trump's legal team has been deploying for years with remarkable consistency and, until recently, remarkable success. But Judge James Moody Jr. of the U.S. District Court for the Middle District of Florida looked at Loomer's case and did something that slap plaintiffs do not expect judges to do. He examined the actual legal merits. And what he found when he examined those merits was a case so fundamentally flawed that it could not survive summary judgment, let alone a full trial. The first and most foundational flaw was the nature of the statement itself. Maher made his comments on a comedy program, in a segment that was explicitly comedic, in a cultural context where the audience's reasonable expectation was humor and exaggeration, not factual reporting. The judge ruled that no reasonable viewer watching Real Time with Bill Maher would have interpreted the joke as a verifiable statement of fact, and in American defamation law, that distinction is everything. You cannot defame someone with a statement that a reasonable person would understand to be opinion, satire, or humor. The First Amendment does not protect lies dressed up as facts, but it absolutely protects jokes dressed up as jokes. Loomer's entire case rested on the argument that Maher's joke crossed the line from protected comedy into actionable defamation. The judge said it did not come close. But here is where the case gets truly devastating for Loomer personally, and where the lesson for Melania becomes almost painfully direct. Even if the judge had found that Maher's statement could be interpreted as factual, Loomer's case would still have collapsed on the question of damages. Because in a defamation case, the plaintiff does not just have to prove the statement was false and made with the required level of intent. The plaintiff has to prove that the statement actually caused harm, real, measurable, documentable harm to their reputation or their finances or both. And when Loomer's own lawyers put her on the stand and asked her about the impact of Maher's joke on her life, what came out of her mouth was the most self-defeating testimony imaginable. She testified that her income increased in 2024 compared to prior years. She testified that she continued to speak to and meet with President Trump. She testified that Trump continued to solicit her opinions. She testified that she continued to receive invitations to the White House. Judge Moody looked at that testimony and wrote in his ruling that the remaining evidence of alleged damages was entirely speculative. In other words, Loomer walked into a courtroom to sue Bill Maher for destroying her reputation and proceeded to testify under oath that her reputation was fine. Her income was up, her access was intact, her relationship with the most powerful person in the world was completely undamaged. The judge essentially said, if your reputation is this good after the allegedly defamatory statement, what exactly are you here to collect? That question, stated with the dry precision of a federal judge who has seen too many cases to be impressed by bluster, is the question that should be keeping Melania Trump's legal team awake at night. Because it is the same question that Michael Wolff's attorneys are going to ask in discovery. What exactly did Wolff's statements do to Melania Trump? She is still the First Lady of the United States. She still lives in the White House. She still commands a global platform and a level of public attention that most human beings on the planet will never come close to experiencing. She still has access to the most powerful office in the world. She still has resources that place her in a category of privilege occupied by perhaps a fraction of a percent of the global population. When Wolff's lawyers ask her to demonstrate in concrete, documentable terms what damage his reporting caused to her reputation or her finances, the answer is going to face the same problem Loomer's answer faced. Because the harder it is to demonstrate actual harm, the harder it is to win a defamation case. And the harder it is to win a defamation case, the more the entire legal strategy collapses into exactly what Wolff has been calling it from the beginning, an intimidation campaign. Now let us look at the specific flaws in Loomer's approach, because they map almost perfectly onto the flaws in Melania's approach, and understanding one helps you understand the other. Loomer's first fundamental mistake was treating a joke as though it were a news report. She filed a case that required a judge to find that a reasonable person watching a comedian on a late-night comedy program would have walked away believing they had just received factual information about a real romantic relationship. No judge applying American defamation law seriously was ever going to find that. The context destroyed the case before the first motion was ever filed. Melania's equivalent mistake is treating Wolff's journalism as though it exists in a legal vacuum separable from his decades of documented work, his established methodology, his publicly stated sourcing, and the broader evidentiary record that includes FBI documents, photographs, and witness statements that corroborate rather than contradict his reporting. You cannot successfully argue that a journalist's work is defamatory when the documentary record keeps producing material that points in the same direction the journalist was pointing. Loomer's second mistake was the damages problem. She could not demonstrate harm because the evidence of harm was completely undermined by her own life, continuing to go remarkably well after the allegedly defamatory statement. Melania faces a version of the same problem. Wolff's lawyers are going to ask what specific, measurable damage was done to the Melania brand by his reporting. They are going to look at her continued presence in the White House, her continued public platform, her continued access to global media, and they are going to ask a judge to find that a journalist's reporting caused quantifiable harm to a woman who remains one of the most visible and powerful figures in the world. That is a hard argument to make, particularly when the plaintiff is the one who filed the threatening letter that started the entire legal fight. Particularly when the plaintiff is the one who escalated a journalism dispute into a federal lawsuit. And particularly when the plaintiff is the one whose own conduct, the industrial-scale intimidation campaign that Wolff has documented across multiple targets, is itself the subject of the case being litigated. Loomer's third mistake, and this is perhaps the most instructive one for Melania, was the strategic miscalculation about what a public lawsuit actually does to a story. Loomer wanted the lawsuit to make the joke go away. Instead, the lawsuit made the joke permanent. Before the lawsuit, Maher's comment was a single moment on a cable television program that most people had already forgotten. After the lawsuit, it became a documented legal case that generated hundreds of news articles, hours of television commentary, and a federal judge's ruling that is now part of the permanent public record of American defamation law. The attempt to suppress the story using legal force did not suppress it. It amplified it. It gave it a permanence and a legitimacy that the original joke never would have achieved on its own. And it ended with a federal judge writing in an official ruling that Loomer's own testimony proved she had not been harmed, which is not the outcome the lawsuit was designed to produce. Melania Trump made the same strategic miscalculation on a significantly larger scale. And what makes her miscalculation so much more catastrophic than Loomer's is not just the scale of it. It is who she chose to threaten. Because Loomer sued a comedian, a man whose entire professional identity is built around making jokes that powerful people find uncomfortable. Melania Trump sent her billion-dollar threatening letter to Michael Wolff, and Michael Wolff is not a comedian. He is not a blogger. He is not an anonymous social media account that can be pressured into deletion. He is one of the most credentialed and deeply sourced political journalists in the United States, a man who has spent decades operating in the innermost circles of American power, with a level of access that most journalists spend entire careers trying and failing to achieve. He wrote Fire and Fury from inside the Trump White House. He did not report on that world from the outside looking in. He was in the rooms, he was in the conversations. He knows how that world operates, who the players are, what they say when they believe the cameras are off, and precisely where the bodies are buried. And his knowledge of the Epstein-connected world around Trump and Melania is not secondhand. Wolff interviewed Jeffrey Epstein himself, multiple times. He sat across from one of the most dangerous and connected men in the history of American elite society and asked him questions and listened to the answers. He knows what Epstein said. He knows what Epstein claimed. He knows what Epstein described about his relationships with the people in his orbit, including the people who are now in the White House. When Wolff says that Melania's April 9th press conference statement contradicts what Epstein directly said about her, he is not speaking theoretically. He is speaking from personal documented knowledge accumulated across multiple interviews with the man at the center of the biggest scandal in modern American history.